Good morning or afternoon, depending on where you are joining us from today. My name is Stephen Penrod, and I would like to welcome you to the webinar. I am a partner in the Employee Benefits Practice Group of Thompson Hine's Cleveland office. I am joined today by Beth Mandel, a senior managing associate from our Cincinnati office. Today, Beth and I will review health plan compliance issues that employers should consider when planning for 2022 and the end of the COVID-related relief. The webinar is the second in a series of 4 slated every Wednesday at noon during October. Each webinar will explore a different benefits-related topic. Please join us every week or just for the topics of interest for you. You can register for additional webinars through the invitation you received or on the Events tab on the Thompson Hine website. Each webinar will offer CLE and a certificate of attendance for those who would like it. To proactively address a question we frequently receive, today's webinar is being recorded and will be sent to all registrants within approximately 2 business days. During today's presentation, please feel free to use the question panel at the upper right-hand corner of your screen. We will answer questions at the end of the webinar as time permits. And now we will begin today's program. So if you attend, oh, do you want to go ahead? Go ahead, Beth.
Okay, so I was just gonna go over last week's webinar, which was presented by Kim Wilcoxon and Laura Ryan, covered a number of topics, including COVID vaccine issues, COBRA issues, CAA readiness. We are not going to talk about those issues today. If you did miss last week's webinar, we can provide a recording of that. So if you did not get the recording and you'd like to see that, please email one of us. As far as topics that we're going to cover today, we're going to look at mental health care compliance, or Mapia, cross-plan offsetting, sex discrimination and benefits coverage, fertility benefits, best practices with respect to responding to document requests, claims and appeal, information requests, some state and local compliance issues, and then some other current issues and 2022 planning considerations. And I'll go ahead and get started with the mental health care compliance. Just to give some background of where we are currently with respect to mental health care regulations. So these laws have actually been around for a while, although I would say in part due to increased DOL enforcement action and in part due to the CAA that came out late December of last year, we're seeing a significantly increased focus on compliance with respect to mental health care parity. So in the beginning, we started out with the Mental Health Parity Act of 1996. This focused specifically on mental health care and on some financial limitations. And then that was broadened in 2008 with what we now know as the Mental Health Parity and Addiction Equity Act, or Mapia, that expanded to address protections related to substance use disorder benefits and impose additional parity requirements with respect to financial and treatment limitations. So these laws in general apply to any group health plan or health insurance issuer who is offering a group or individual health care plan that covers mental health care or substance abuse disorder care in any manner. There are some exceptions. For example, the law does not apply to benefits that are purely HIPAA accepted benefits. So for example, your standalone dental and vision, accepted benefit EAPs, FSAs, benefits of that nature are not going to be subject to these mental health care or mental health parity laws. So we're primarily looking in most cases at major medical and prescription drug plans. We've seen a steady stream of guidance. Next slide, please, Stephen. We've seen a steady stream of guidance over the past decade related to Mapia enforcement. All of this guidance is available on the DOL's dedicated website with respect to Mapia. It includes things like tri-agency FAQs. There's a very detailed and pretty helpful self-compliance tool that we'll talk about a little bit more later in this presentation that I encourage folks to go ahead and take a look at if you have not already. This is a really good resource for you to rely on in evaluating your own plan's compliance. So big picture, Mapia is designed basically to create parity between the medical surgical side of the benefits being provided under your plan and then the mental health and substance use disorder side. So in general, benefit plans are not required to cover mental health and substance use disorder benefits, but in the vast majority of cases, plans do cover these benefits. In fact, I've never come across a plan that just wholesale excluded mental health care and substance use disorder benefit coverage. And so when you offer those benefits, then there are going to be requirements and restrictions around how you are offering those benefits, how you're administering those benefits. If you are offering those benefits, you have to offer them across 6 categories in your health plan. We'll talk about what those categories are in a little bit, but basically you have to offer them broadly across all different types of care within your health plan. So for example, inpatient, in-network treatment, outpatient, prescription drug coverage. You can't, for example, cover prescription drugs for mental health or substance use disorder purposes, but not provide any other benefits related to mental health or substance use disorder conditions. And then if you are providing these benefits, you have to make sure that you are maintaining your maintaining your plan and administering your plan in a way that ensures parity between the medical surgical side and the mental health and substance use disorder side with respect to annual and lifetime limits, financial requirements, and quantitative treatment limitations. So an example of financial requirements would be your deductible that you charge, your out-of-pocket maximum. Quantitative treatment limitations would be limitations like placing a limit on the number of outpatient visits that a person can receive coverage for during a plan year. And then we get into non-quantitative treatment limitations. And that's going to be the focus of my presentation today, because that currently is the focus of the DOL's enforcement efforts. So the DOL, as I said, definitely considers Mapia to be an enforcement priority. I think at every single presentation that I've seen over the past couple of years where there has been a DOL representative, they have, focused, if not spent the majority of the presentation talking about mental health parity compliance. So it is definitely front and center for them. And they are emphasizing the NPTL, the non-quantitative treatment limitation compliance. They did announce 3 focus areas for fiscal year 2021, and those included processes for determining whether provider reimbursement rates might indicate a Mapia violation, accuracy of provider network directories, and then treatment limitations regarding autism spectrum disorder. As we'll talk about later, autism spectrum disorder has also been a focus of much of the participant litigation related to mental health parity. Okay, so NPTL compliance overview. So what are non-quantitative treatment limitations? Some examples include prior authorization or pre-certification requirements, medical necessity requirements, conditioning benefits on completion of a course of treatment, fail first or step therapy protocols, prescription drug formulary design, which a lot of people don't think of as a non-quantitative treatment limitation, but depending on the manner in which the formulary is designed, if it's designed to exclude or make it more difficult to obtain coverage with respect to mental health, with respect to drugs used for mental health services or substance use disorder services, then that could be viewed as an impermissible non-quantitative treatment limitation. So what we generally see when we're looking at all of these is that, and Stephen, if you go to the next slide, it's not that you can't use things like medical management. It's not that you can't apply pre-certification requirements to mental health services, substance use disorder services. But the application of those types of limitations need to be on par with the manner in which you're applying those limitations to medical and surgical benefits. So boiled down, the test for Mapia compliance basically is, are the processes, strategies, evidentiary standards, or other factors that are used in applying the non-quantitative treatment limitation applied to mental health and substance use benefits in a manner comparable and not more stringent. So comparable and not more stringent when applied to medical and surgical benefits in the same classification. And we'll take a look at a case example later in the presentation where that same classification requirement was a crucial factor that the court looked at. But in general, there are only 6 classifications. So when you're looking at these benefits, for example, if you have a pre-certification requirement for inpatient, out-of-network mental health treatment, then in order to determine whether that treatment limitation is in violation of Mapia, you would look at, okay, what do we require for the medical surgical benefits that are inpatient, out-of-network benefits? And are we applying the same types of pre-certification requirements to coverage of inpatient services with respect to those types of conditions, medical surgical conditions? Are we applying those pre-certification requirements in the same manner? Are we allowing more, discretion with respect to medical surgical? So those are the kind of questions that you would dig into to determine whether or not you potentially are not in parity.
Hey, Beth.
Yeah.
We got a question from a participant regarding the 6 permissible classifications. The question is, are there sub-classifications within these 6 permissible classifications?
So it's interesting. There are some sub-classifications that have been recognized with respect to financial treatment limitations. And in the financial treatment limitation or quantitative treatment limitation analysis, there have been a limited number of sub-classifications that plans are permitted to look at. So for example, for outpatient services, you can look at subclassifying that category into office visits and all other outpatient items or services. But for the non-quantitative treatment limitation analysis, we really haven't seen recognition of any sub-classifications. And in fact, the sub-classifications that were permitted with respect to the financial treatment limitations wouldn't necessarily carry over or make sense in a non-quantitative treatment limitation context. So possibly we'll see some guidance on sub-classifications in the future with respect to NPTLs, but we don't have any at this moment. Another important point on this analysis is that the NPTL has to be analyzed both in writing, so both based on what does the plan say, what is the facial term of the plan, and then as applied. So we know what the plan says, but what's actually happening behind the scenes when you have someone at your TPA who's looking at whether the pre-certification requirement has been met with respect to this particular claim. Some examples of how to check for compliance when we're looking at as applied. So things to look for, you may want to think about doing almost a mini audit or a check of sample claims to determine whether a particular NQTL warrants additional review. If you have written processes that are compliant on their face, but those processes are being applied in a non-compliant manner, and maybe that's coming through based on increased denials for mental health or substance use disorder claims, that's something that you might be able to pick up on a claims audit involving a sampling of claims. Also think about, do the processes for applying the NPTL allow for exceptions, discretion, manual overrides? If so, consider how and when those exceptions are permitted to be applied, how much discretion is permitted, things of that nature. NPTL warning signs that have been suggested by the DOL. So one of the tools that the DOL has released that's on that main DOL Mapia website is a list of and description of warning signs. And some of these warning signs include things like the plan requires pre-authorization for all mental health substance use disorder benefits. The plan requires concurrent care review every 10 days for coverage of mental health substance use disorder services. The plan's medical management program delegates review of surgical medical benefits to attending physicians, but conducts its own reviews for mental health and substance use disorder benefits. So in some cases, these red flags may not actually amount to an NPTL violation, but they are, it's a good tool to kind of look at, go through your plan, see if you have any of these red flags, and then if you do, examine whether the limitations are being applied consistently across the medical, surgical, and mental health substance use disorder services.
Hey,
Okay,
Beth.
so, yep.
We got one more question.
Okay.
The question is, what do you do if the Department of Labor, what's the Department of Labor expect if you don't get compliance with your third-party administrator? You either have difficulty, getting, information about compliance, or they just aren't responsive.
Yeah, so I think this relates to, I'm going to just go over really quickly before I answer this question, because I think that is getting a little bit ahead of ourselves to probably what people are most concerned with, which is that the CAA, which was issued late last year, now basically requires the DOL to request reports, analyses of NPTLs from plan sponsors. They're required to request a certain number per year, and plan sponsors are actually required to ensure that they have conducted an annual review of their NPTLs and have written analyses that they can provide. This is in effect now. So this is not something that, like a lot of the CAA provisions is going into effect next year. This is in effect now. The DOL has already been making these requests. The comparative analyses have to address some pretty specific information. You have to identify all your NPTLs. You have to provide a description of all the benefits to which they apply. You have to basically provide that comparative analysis that goes kind of deep into the processes, strategies, evidentiary standards, other factors that you're using in applying the NPTL, and then the analyses demonstrating that both as applied and as written, those processes, factors, strategies are being applied on a consistent basis and on par with medical surgical. And then you also have to include specific findings and conclusions. So of course, these are pretty detailed reports that the DOL is looking for. And as we know from practice, most of the time plan sponsors do not have the information that they would need in order to complete these reports, in order to do the underlying analyses. And so plan sponsors have to rely heavily on their TPAs for the self-insured plans, the insurers for the fully insured plans. And I definitely understand the concern. We've heard from a lot of clients who are just having a really difficult time getting this information from their TPAs, don't really know what to do with the information all the time when they get the information, depending on what format it comes over in, if they're just getting like a big data dump or if they're getting some actual analysis from the TPA, not sure kind of how to evaluate it to determine if it's fully compliant. We're going to walk through some steps that you can take in working with TPAs on this in a moment, but I would say, first and foremost, the DOL has expressed unfortunately over and over that they first of all, do not view this as a new requirement. If you remember back to the overview, these requirements have been around for a while. It's just now that we have this mandate for the DOL to start requesting these written analyses, but the DOL kind of feels like plans should have been doing this all along. And so they don't have a lot of sympathy for plan sponsors who, don't have anything prepared, just say, oh, my TPA wouldn't give me anything. So they're really expecting plan sponsors to take affirmative steps to try to work with their TPAs to get this information, get these analyses done, and to the extent that you have to maybe hire a third-party consultant or another third party to assist with these analyses. The DOL did say recently that they want to know if you really are having a difficult time getting this information from your TPA, or your TPA just is unwilling to work with you on this. So if you can demonstrate that you have made good faith efforts, that you've exercised due diligence in trying to get your TPA to work with you on this, trying to get information, and your TPA really just is, taking a completely hands-off approach, the DOL wants to know that, and I suspect there may be some additional willingness to work with the plan sponsor in those situations, but I wouldn't rely on that. It would have to be, a pretty egregious situation, I think, where the TPA is just completely unwilling to provide any data or analysis. So the DOL or the tri-agencies did issue some FAQs this year with respect to mental health parity and how the new reporting requirement is going to be implemented. The key of these, I guess the key takeaway from these FAQs is just that the DOL is really expecting something more than a general statement of compliance. They want more than cursory references to the strategies and evidentiary standards that are being used. They want you to actually show your work. So how did you analyze these strategies, the standards? How did you determine that they were being applied consistently with respect to mental health and substance use disorder benefits versus medical and surgical benefits? They do have some focus areas that they've announced, but just because they've announced these focus areas doesn't mean that they're not going to expect analyses of all NPTLs. So keep that in mind. It's not sufficient to just focus on what they've announced as their priorities. So how these requests typically come in and how the process goes. So what we've seen, and this is just based on pure observation, we have no confirmation from the DOL to back this up, but it does seem like the plans that are being hit with the requests are plans who possibly have had some sort of inquiry or complaint related to mental health parity filed with respect to the plan in the past. So a lot of times the DOL has been requesting information first on one or two specific areas or specific non-quantitative treatment limitations. And then they'll give you the plan a really short turnaround time for that. So maybe 10 days, 15 days to provide the analyses with respect to those one or two NQTLs. Then after that first phase, the DOL might then turn around and ask for the full analyses. And again, you might get another 15 days to provide that full analyses. But the DOL is not giving plans a lot of time to respond. And from what we've heard, they've been very unreceptive to requests for extensions. After you provide the analyses, then the DOL will review, determine if they think it's compliant, if it's sufficient to meet the reporting standards. If they don't believe it's compliant, then you will have 45 days to submit updated analyses. And if at the end of that 45 days, the DOL determines ultimately that they still believe the plan is not in compliance, then the plan must notify participants of that non-compliance within 7 days and must work with the DOL to address the non-compliance. All right, so issues to consider in addressing the analyses or working toward getting some sort of analyses completed. What we've seen is that in general, fully insured plans, the insurer is willing to prepare the analysis on behalf of the plan. And with respect to self-insured plans, which of course the majority of our clients have, one or more self-insured plans, that's where it gets sticky. So what we've seen with respect to self-insured clients or self-insured plans most commonly is that the TPA, at the beginning was sort of hands-off. Now they're starting to recognize, okay, we have some sort of obligation to assist with this. So now a lot of TPAs are willing to provide analyses with respect to what they consider to be their standard NQTLs. So the NQTLs that they apply for their standard plan designs, which probably are similar to their fully insured plan designs. So they're already doing those analyses. So they're saying, okay, we'll provide those analyses to you, self-insured plan sponsor. The problem with this is that a lot of times plan sponsors don't really know which NQTLs are standard in their plan and which are non-standard. So that's something that we've been pushing TPAs to assist with, is to first of all help us understand what is not standard in our plan. It could be that 4 years ago you adopted an NQTL that was part of your TPA's standard plan design. They then changed their standard plan design. You got a notice telling you, we're making this change. Do you want to stick with old design or change to our new standard? And maybe you thought at that time, old design's working well, we're gonna stick with the old design. All of a sudden, okay, you're in a non-standard plan design. So it's highly possible that you could have non-standard NQTLs that you're not aware of, and maybe the best option at this point is identify those and maybe think about switching to just the standard that's applied by the TPA. If you do end up having, a significant number of non-standard NQTLs, then maybe at that point you think about, is it worth it to bring in a consultant to help evaluate these standards, to help do, a mini audit with respect to the as applied analysis. Let's see, and then other things to consider, don't forget about the carve out. So if you have a prescription drug carve out, you're going to want to work with that prescription drug, the PBM or prescription drug TPA, to address the NQTLs with respect to prescription drugs as well. Okay, litigation risks. There are ongoing litigation risks separate and aside from the DOL's agency enforcement. So we did see actually the DOL taking litigation action earlier this year. There was an example of that with respect to a case in which the DOL sued United Behavioral Health and United Healthcare Insurance Company, alleging that UBI was applying UBH was applying a utilization review program for outpatient behavioral health treatment. It was called the ALERT program, and it was apparently much broader and more aggressive than the utilization review programs that they have in place for medical and surgical benefits. They also targeted the practice of reducing reimbursement rates for out-of-network mental health care providers based on provider licensures in a manner that was not done with respect to medical and surgical benefits. There was ultimately a settlement reached in that case, but it does show that the DOL is, if the DOL is seeing what they believe are systematic violations, they are pursuing relief with respect to those violations. And then just some examples of participant litigation. Recently this year, we saw action in the Doe v. United Behavioral Health case. This involved a plan exclusion of ABA therapy and denial of claims for coverage of ABA therapy for treatment of autism. The court ultimately found that those exclusions violated Mapia, and that the exclusion of ABA therapy created a separate treatment limitation that only applied to services for treating mental health conditions. And then we also saw recently a case against Premera Blue Health. or I'm sorry, Premera Blue Cross. In that case, the court found that the plan violated Mapia by denying residential treatment coverage for a child diagnosed with various mental health conditions, including autism. And in determining whether claims for residential treatment care for a mental health condition met the plan's medical necessity requirement, Premera applied both the terms of the plan and this additional screening tool that they called the interqual criteria. When the court dug into practices related to medical surgical residential treatment, the court found that even though the plan may have been applying this similar interqual criteria to some types of medical and surgical residential treatment, it was not applying it to all types of medical and surgical residential treatment. For example, it wasn't applied to hospice care. And so because the plan was not applying that requirement across the board in that category, inpatient, in-network treatment, then it could not apply that additional screening tool to the mental health and substance use disorder benefits in that category. So that is, I've probably taken up way too much time, and I apologize, Stephen, but that is our wrap up on MHP AEA for this year. There is a lot to dig into with this. We definitely encourage that you talk to counsel about this if you have not already.
Absolutely. Thanks, Beth. So next I'm going to talk about cross-plan offsetting. And so first of all, let's level set by talking about, what exactly are we talking about when we talk about cross-plan offsetting? It's the practice of recovering one plan's overpayment by reducing or offsetting payments made under a different plan. It's also been referred to as bulk recovery process. And this is just an example of this would be, let's say John is covered by a plan A. He goes to provider, provider XYZ and has some services performed, and Plan A is billed $200 for these services, and Plan A pays the services as expected. And then the third-party administrator figures out, well, I think instead of paying $200, we should have actually paid $150. And so the third-party administrator approaches the provider and says, we need that $50 back. And the provider either drags their feet and doesn't immediately respond, or maybe they refuse to pay it. They think it's in dispute, so they don't pay it back. And so now, according to the third-party administrator, the provider owes the third-party administrator the $50. And then let's say another plan participant, Jane, goes to that same provider, but she's covered by another plan. Let's call it Plan B. And she has $200 worth of services provided. So the third-party administrator says, well, we're having difficulty recovering this $50 from John's services. And so instead of trying to recover those services, we will just reduce the $200 we owe for Jane's services by $50, and we'll just pay the provider $150. From the third-party administrator standpoint, they're even. They've paid $300, or actually they've $350 for the services, $150 for John, $200 for Jane, and they're good to go. Except what has happened is they've essentially taken money from Plan B or Plan A in order to pay Plan B, and so it gets kind of messy. So there's been some litigation, and the first was this Peterson versus United Healthcare Group. The Eighth Circuit Court of Appeals found that the United Healthcare lacked the authority to apply cross-plan offsetting to non-participant providers. So this was a case brought by non-participating providers or an out-of-network provider because the plan documents did not authorize the practice. So unfortunately for us ERISA nerds, we didn't get the clarification we wanted from this case because they did not get to the central issue of the ERISA fiduciary duty or prohibited transaction issues. They didn't even get to that because they just found plan documents didn't authorize the practice. Therefore, United Healthcare was at fault, and so they didn't even get to the real meat of the argument. What we did get, however, was a Department of Labor amicus brief, and in that brief, the Department of Labor clearly established their position that cross-plan offsetting violates ERISA, at least with regard to non-participating providers who could potentially come back and balance bill the individual for that amount. And so the example I gave where Jane goes in, gets $200 worth of of services and the plan only pays 150, potentially the provider could come after Jane and look for the $50 to come from Jane, which of course isn't fair because the plan should have paid the entire $200 on behalf of Jane. They did, however, state in their amicus brief that the harm may be mitigated where it's limited to network providers, and those providers have agreed through their contracts with a third-party administrator not to balance bill. And so they admitted that if you have a situation where the providers in network, they've agreed not to balance bill, you may have a situation where it's not necessarily an issue to have cross-plan offsetting. But again, the court in Peterson versus United Healthcare Group did not even get to that point because they found that the plan didn't even permit it. So the second litigation which came about was Scott versus United Health Group. This was actually a class action filed in July of 2020 in the U.S. District Court for the District of Minnesota. It was a class action brought by plan participants. And so while Peterson was brought by non-network providers, this was actually brought by a participant. And again, it was a class action arguing that the cross-plan offsetting harmed the plan and all individuals as a part of that plan. And so they had this class action lawsuit. In May of this year, the district court dismissed the breach of fiduciary duty claims, holding that the participants lacked standing because they weren't denied any benefits and weren't individually injured. This comes up oftentimes with defined benefit pension plan litigation, where participants want to sue on behalf of the plan because there's been a fiduciary breach. And because of that breach, there's been a reduction in the assets. And similar to the defined benefit pension plan scenario, here we have a situation where these individuals got the full amount of the benefits they were entitled to under the plan. And so therefore, even if there was some sort of a fiduciary breach, these individuals just didn't have the standing because they weren't injured. They didn't have actual injury. This was actually, so again, it seemed like a promising case, but we didn't quite get the result we wanted, some clarification as to exactly what the cross-plan offsetting does from an ERISA standpoint. So the third attempt was Lutz Surgical Partners versus Aetna. This was, again, healthcare providers. They were plaintiffs. They sued Aetna, alleging the practice of cross-plan offsetting violated ERISA's prohibited transaction and fiduciary rules. So again, this is really the meat of the argument that us ERISA nerds were interested in. And so the U.S. District Court for the District of New Jersey in June of this year granted summary judgment. And just to clarify, these healthcare providers were non-network providers, so similar to the Peterson case. However, they were suing on behalf of participants. So this was sort of a hybrid court action where they were suing on behalf of plan participants as non-network providers. So the district court granted summary judgment. They said that the cross-plan offsetting resulted in a prohibited transaction. It also resulted in a violation of ERISA's fiduciary duty of loyalty. And even if the plan documents permitted this cross-plan offsetting, those documents could not circumvent ERISA's requirements. So again, a little bit of clarification in this case that we didn't get in the prior two. However, it still didn't quite get us exactly where we want, the clarity we want as advisors, because it did not address whether it violates ERISA, if it's limited to network providers, because again, these were out-of-network providers. It also did not address whether the benefit plans anti-assignment clauses precluded providers' claims. So, we have oftentimes anti-assignment clauses in plans, and so if that provision were in this plan, would that have precluded the providers' claims in this case, because they wouldn't be able to represent the participants in this case. So again, a little bit of guidance, but stay tuned because we anticipate this to become a further issue for plans going forward. So what issues should you consider as a plan sponsor or a plan administrator? I guess the first question is, does the plan's third-party administrator engage in cross-plan offsetting? Obviously, if they don't, your analysis is over. But if so, are there limits in place on that practice? Again, is it just limited to network providers or in certain circumstances? And has the plan made a fiduciary decision to determine whether to allow the practice to continue? Arguably, if this cross-plan offsetting is taking place, this really needs to be a fiduciary decision, because again, the fiduciaries for the plan need to make decisions as to how assets of the plan are being used, and if this cross-plan offsetting is taking place, the fiduciary needs to be not only aware of it, but really needs to have signed off on it in order for it to continue. And then lastly, does the SPD allow this practice according to its terms? And then the next question is the cross-plan offsetting addressed either generally or specifically in the vendor services agreement with your third-party administrator? Is it expressly permitted? Is it absolutely expressly prohibited? Or is it limited, again, maybe to just network providers, and it's not used in a non-network provider scenario? Is there some special indemnity, especially given this latest litigation? It certainly would be in the best interest of the plan or the plan sponsor to have an indemnification if there is a cross-plan offsetting provision in the services agreement that says, listen, if this is found to be unconstitutional or against ERISA, then are you, third-party administrator, going to reimburse us for the potential fees and expenses associated with this, or having to go back and re-adjudicate some of these claims and things like that? I mean, this could be a very costly loss if a plan were to lose on this litigation. And then is there specific reporting required by the services agreement? Again, back to that fiduciary question. If it's a fiduciary decision, whether and to what extent to spend expenses on from the plan, and cross-plan offsetting is taking place, the plan fiduciaries really need to have an understanding of what and to what extent these fees are being paid in order to just determine whether, in their fiduciary duty, discharging their fiduciary duty, whether they are permissible to continue. So, Beth?
All right, so the next two topics that I'm going to cover are somewhat related. The first topic is sex discrimination and benefits coverage, and then the next topic is fertility. And I say they're related because when we look at sex discrimination and benefits coverage historically, a lot of the cases involving allegations of sex discrimination related actually to coverage of maternity or early fertility types of benefits. And then recently, especially the last few years, we've seen increased litigation related to gender dysphoria issues, gender transition coverage. And last year, we in particular saw a flurry of activity at with respect to the Supreme Court, and then with respect to some rules that were issued under Section 1557. So starting with the Supreme Court, last year we saw the Supreme Court rule in Bostock v. Clayton County that Title VII of the Civil Rights Act protects employees against discrimination because of their sexual orientation or gender identity. So essentially, discrimination on the basis of sex includes discrimination on the basis of sexual orientation or gender identity. This Supreme Court ruling significantly increases risks to the group health plan if you have a plan that excludes coverage for treatment of gender dysphoria or gender transition services, excludes coverage of same-sex spouses, includes same-sex domestic partners, but excludes opposite-sex domestic partners, and then the vice versa. Looking at the application of Title VII to plan design, the EEOC has historically said that disparate impact exists when a health plan excludes a treatment that exclusively or nearly exclusively affects members of one protected group. So, and when we look at this now in light of Bostock, we have to remember that at this point, individuals could be a protected group based on their sexual identity, not just on the basis of biological sex. And so if you have disparate impact that exclusively or near exclusively impacts a protected group, the employer has to show that the exclusion is based on generally accepted medical criteria. And we did see an example of this play out in a federal case recently In that case, the court held that the exclusion of coverage for gender transition services is discriminatory on its face and is direct evidence of sex discrimination. And they found that there was no bona fide occupational qualification that would justify the disparate treatment. One thing to keep in mind is that the EEOC, when looking at justifying the separate treatment, cost is not a justification. So that will never be an acceptable justification. Section 1557. So these are regulations under Section 1557 of the Affordable Care Act that prohibit discrimination with respect to certain aspects of health coverage. And the regulations generally apply to group health plans who receive federal funding and other categories of group health plans and entities. But for the most likely, to the extent that employers are going to be subject to this, it's because they're receiving some sort of federal funding in connection with their group health plan, like federal retiree drug subsidy funding. So historically, the regulations that were issued under Section 1557 included language that would have defined discrimination on the basis of sex to include discrimination on the basis of gender identity. Last year, we got new regulations issued under Section 1557 that essentially did away with that. They didn't contain a prohibition against healthcare exclusions of coverage for gender transition services, treatment of gender dysphoria, like had been in the prior regulations. And they didn't require covered entities to provide a non-discrimination notice and taglines with significant publications. So what was the effect then of Bostock on Section 1557? Well, after the Bostock opinion came out, which came out, I think, 2 days after the Section 1557 regs were first issued, after Bostock came out, you saw a flurry of commentary and some lawsuits basically arguing that it is no longer permissible or feasible to interpret Section 1557 in the manner that HHS had. And then what we saw is basically this year, this administration came out with guidance indicating that HHS will interpret Section 1557 in a manner that's consistent with Bostock. So now we're looking at both Section 1557 and Title VII, looking at sexual orientation, sexual identity as potentially a protected classification. So issues to consider when looking at this are, does your medical plan cover services related to gender transition or treatment of gender dysphoria? Do you have any restrictions on that coverage? Is the coverage clearly described in the SPD? And if not, do you risk claims that you are potentially violating either Title VII or Section 1557? Other issues to consider when looking at gender dysphoria exclusions, just going back to mental health parity for a moment, is that it's also possible that if you are excluding a certain type of treatment for sexual or gender identity disorder, that may trigger a Mapia violation as well, depending on how that's structured. So lots of issues to keep in mind, but definitely a red flag if you've got any sort of exclusions related to treatment of gender dysphoria and something to look into further. Okay, fertility benefits. So we've seen a lot of employers, I'm going to kind of quickly go through this because we have 10 minutes left. A lot of employers have expressed interest in expanding fertility benefits. There's been a lot of interest in trying to qualify for the HRC equality index, and then just a lot of interest in expanding benefits so that they can attract qualified candidates. Common issues when you're thinking about including or expanding fertility benefits are benefit design issues, taxation, and then discrimination concerns, getting back to the Bostock issue. So benefit design considerations. When you are adding fertility benefits, are you creating a separate group health plan, or are you functionally just adding additional benefits to your pre-existing major medical plan? If you are creating a separate group health plan, for example, you offer a major medical plan, you also offer a suite of fertility benefits from a third-party administrator who specializes in fertility benefits, you're not going to require that individuals be enrolled in your group health plan in order to take advantage of the fertility benefits. So you're just going to pay for, you're just going to cover whatever premium there might be for participating in the fertility benefits, and any of your full-time employees can participate regardless of whether they're enrolled in your major medical plan. At that point, you probably have created a separate group health plan with respect to fertility benefits. So then the question becomes, you know, is this in any way an accepted benefit? Probably not. We've seen, you know, some cases where limited fertility benefits could potentially be classified as a accepted benefit EAP if it's, you know, limited to certain forms of like coaching or kind of, you know, light benefits of that nature. But if you're actually providing, you know, thousands of dollars of fertility care in fertility treatments, probably you're looking at a situation where you're providing significant coverage in the nature of medical care, and that's going to bring you out of an accepted benefit design. So then you've got issues of ERISA compliance, COBRA compliance. You know, are you separately offering COBRA for this benefit when somebody terminates? Do you have a separate plan document to ensure ERISA compliance? How are you handling the administration of claims and appeals? And then, of course, we have the ACA healthcare reform coverage mandates to consider. So in order for a non-accepted benefit group health plan to comply with healthcare reform, the plan has to cover all types of preventive care services, which your standalone fertility plan probably is not doing. So it's going to be very difficult to meet all of these compliance requirements if you are not somehow linking or bundling your fertility benefit with your major medical plan. If you are bundling with your major medical plan, things to consider include cost sharing and how you're going to administer that cost sharing. So, you know, how are you going to apply the deductible and out-of-pocket maximum? How are you going to make sure if you have an HSA medical plan that you are not providing pre-deductible first dollar coverage with respect to fertility benefits in a manner that could disqualify someone from being able to contribute to their HSA. There are taxation issues to consider. So in general, you know, the benefit can only be considered a tax qualified benefit if it's considered to be medical care under the Internal Revenue Code. Medical care is defined pretty broadly to include services or items related to the diagnosis, cure, mitigation, treatment, or prevention of disease, or for the purpose of affecting any structure or function of the body. But it can get kind of tricky as to what actually qualifies when you start to dig down into what's a taxable versus non-taxable benefit. For example, egg donor costs incurred by a single heterosexual male taxpayer seeking to have a child through unrelated egg donor or surrogate, that would not be considered a tax qualified benefit because it's not related to an underlying medical condition or defect of the heterosexual male taxpayer, nor is it incurred to affect a structure or function of that heterosexual male's body. All right, sex discrimination. There have been some recent cases that are popping up involving allegations that plans are discriminating against same-sex individuals or same-sex couples by failing to provide equitable coverage with respect to fertility benefits, in the sense that a lot of these plans require that you know, an individual demonstrate that they've tried to get pregnant through sexual intercourse for a certain period of time before benefits are covered. Well, obviously that's not going to apply to a same-sex individual. And so we've seen some litigation pop up in that area. Out of interest of time, I'm not going to go into detail, but if anybody has questions, please feel free to contact me. Other issues to consider when looking at benefit designs for fertility are just HIPAA privacy and age discrimination issues.
Thank you, Beth. So now I'm going to quickly go over some best practices for claims and appeals procedures and when you get requests for documents. Plan documents and SPDs, it's good to have a general statement of non-assignment, both with regard to benefits, but also the broader category of rights in your plan document, your SPD, for a number of different reasons. It sort of limits the number of providers that can try to file under your claims and appeals process. It requires them to comply with your plan's procedures and things like that. Forum selection is always a good idea. It requires individuals to file litigation within your home court, literally, and so that avoids the having to defend a litigation case, especially if you have employees across the United States. It avoids you having to defend a case in a small, faraway place. And statute of limitations. ERISA by itself does not have any statute of limitations, but one way in which you can have statute of limitations that limits your liability for past benefits is by having a statute of limitations in the plan, so that you can avoid having somebody come back 6, 8, 10 years after they've had services claiming that that you owe them money for that. Document request considerations. This comes up an awful lot more recently. The question is, what are relevant documents, records, or other information that can be requested under ERISA Section 503? We just recently had an EBSA information letter. This was requested by an attorney for a claimant who had been denied access to recordings of discussions between the claimant and the plan. The reasons given were that the recordings were strictly for quality assurance purposes and were not used in the determination of the claim, and the Department of Labor said no, that's incorrect. It essentially is a document or information that was generated in the course of the claim and therefore needs to be provided, even if it wasn't used in the actual determination of the claim or appeal. So that's important to have some conversations with your third-party administrators to see how long they maintain records or transcripts of conversations, and making sure that you have those available if you have a claim or appeal that comes up. Administrative services agreements with third-party administrators. This is another area. There's the general catch-all of other instruments under which the plan is established or operated, and administrative services agreements. Courts have held that those can be required to be provided under that provision. There was a recent case that held that the agreement affects the relationship between the plan participant and the provider. Therefore, it's essential that that be provided to the claimant. And so, you do want to have a conversation with your third-party administrator about possibly redacting provisions of the agreement regarding confidential information, but you may still have to provide that administrative services agreement to a claimant upon request. And then provider requests and authorizations. As I talked about a few minutes ago, oftentimes providers will try to end around the ERISA provisions by claiming that they have authorization of the participant, and therefore acting on behalf of the participant, and have the rights to request information because of that.
All right, state imposed or state benefit issues. Just really quickly, just keep in mind that there are a number of state imposed individual mandates that have associated reporting requirements. We've listed the current reporting requirements here, but just something to keep in mind. If you haven't been doing that, look into what your potential reporting requirements are and what you may need to do to take corrective action. And then other state and local laws. There are a host of state and local laws that are increasingly popping up in various areas related to healthcare spending, health coverage requirements, commuter benefits. We've seen some action recently in Washington with respect to a long-term care fund tax and an additional fund assessment related to mental health and behavioral health care services. Just as a plug, we're going to be launching a state law benefits newsletter very soon. The first newsletter will address the newer Washington requirements. So keep an eye out for that. That'll contain additional information. And then in our last 30 seconds, we've just got some other issues for you to keep in mind as you're going through the end of the year and planning for next year.
So Blue Cross Blue Shield antitrust class action settlement, the deadline for filing a claim is November 5th of this year. So make sure if you are in any way impacted by that, you don't miss that deadline. HIPAA privacy regulations were initially proposed and then withdrawn. Keep an eye on that because we anticipate those to come out at some point soon. EEOC wellness program guidance. There's been a lot of recent guidance, especially with regard to vaccination incentives. So again, if you have any questions about that, feel free to contact your friendly neighborhood Thompson Hine attorney about that. Flex credits and lifestyle accounts. Number of clients are asking questions about sort of above and beyond what's currently being provided and sort of expanding flex credits. And so that's another hot button topic to talk about. Voluntary insurance product commissions. Again, be careful when you're setting those up that you don't have scenarios where you're using plan assets for non-plan expenses or vice versa. And then the deadline extensions related to COVID-19 national emergency. Keep an eye on that. We hope that we'll have the national emergency ending soon, but we've had some recent guidance on COBRA payments and how that's related to that. So make sure you, again, keep on top of that and talk to your Thompson Hine attorney for that. So if you'd like to apply for CLE or HRCI, please note the attachments in the handout section in the control panel. You will need to print and complete the attorney affirmation form to receive credit or a certificate of attendance. You will need a code to complete the form. Today's code is TH1013. That is T as in Tom, H as in Harry, and the number 1013. Please also spend a few moments to complete and submit the feedback form also in the handout section. Thank you for attending our presentation. As mentioned, we will send the recorded webinar and slides to all registrants. If you have questions we are unable to get to, please reach out to your Thompson Hine attorney. If you aren't currently a client, contact Beth or me. We will discuss available options to address your needs. Remember, if you need CLE or HRCI credit, please download and complete the affirmation form and follow the directions and use codes TH1013. Thank you so much and enjoy the rest of your day.